Hi, I'm Anna Denton-Jones of Refreshing Law, and in today's session I want to talk about constructive dismissal. Most people will be familiar with the concept of gross misconduct, and when an employee does something that's really bad, the employer can treat that behaviour as bringing the contract of employment to an end, in which case the employee's employment ceases without the employer having to pay the employee anything. And constructive dismissal is really the flip side of that. It's a circumstance where what the employer has done to the employee is so bad that the employee gets to walk away from the relationship. If they don't want to give notice, then they can choose to leave immediately and not work out their notice period, although contrary to lots of people's beliefs, an employee can choose to resign giving notice as part of their leaving as a result of what the employer has done. I mentioned that the employer needs to have done something really bad for the employee to be in this position. And the way the law looks at it is to say that one of the critical ingredients for a successful constructive dismissal complaint is that the employer has done something that amounts to, in legal jargon, a repudiatory breach of the contract of employment. So that means the employer has done something that is a fundamental breach of the contract. So in any given case, the employee's got to identify what that breach is, what term of the contract has been broken, and show that it is of that serious enough nature to enable that to happen. Before we talk about what sorts of things might be a fundamental breach of contract, it's worth just emphasising that this has got nothing to do with what the employer intends. So the fact that the employer wasn't intending to breach the contract doesn't mean that it hasn't happened. So what sorts of things are going to count as a fundamental breach of contract? Some things are quite obvious, like cutting somebody's pay, changing their bonus and commission arrangements without an agreement from the employee in relation to that, unilaterally changing their working hours or what's included in their job duties, particularly with professional people, things like employing them to do a particular job and then not actually giving them that work to do, so they start to be de-skilled. Insisting that they work hours over and above that's agreed in the contract. Suspending them when you haven't got the right to do that in the contract, or laying them off when you haven't got the right to do that in the contract. But also it might be a breach of an implied term of the contract. So you all know that there's an implied term in the contract that we will provide the employee with a safe working environment. So obviously there's a big dovetail there with things like bullying and harassment, health and safety. If we're not looking after somebody, if we're not enabling them to work in a suitable temperature and a suitable working environment, then that could be a breach of an implied term. We'll also cover things like the duty to promptly investigate grievances. So I often see situations where employers are really not taking grievances seriously, not dealing with things quickly enough, which could lead to the employee saying there's been a breach of this implied term in relation to the prompt dealing with grievances. There's this concept of trust and confidence in the contract of employment. It's implied into every contract, and that the employer mustn't take steps that breach that implied duty of trust and confidence. So it's a bit of a catch-all category, really, where the judges can't fit the breach of contract into other categories. Quite often it gets shoved into this trust and confidence type idea. The sorts of things that will fall within that label do have a big overlap with things that are to do with following a fair process. So the things that your policies and procedures say that you're going to do, the things that the law says is good practice, so things like the ACAS Code of Practice on disciplinary grievance procedures, or fair processes from the perspective of unfair dismissal and managing somebody's performance, their sickness absence, a disciplinary situation, a grievance when it's been raised, or a redundancy process. So things like not investigating somebody's grievances or complaints, or when we do an investigation, doing it in an inept way, so using the wrong people who don't have the skills to do that investigation properly. It might be in a disciplinary case something like the sanction that's awarded at the end of the disciplinary hearing being out of all proportion to the facts of what the person has done wrong. And that kind of knee-jerk reaction that you sometimes get from managers where they want somebody sacked for, something really trivial. It can even extend to things like telling people that their employment is coming to an end for one reason when really there's something else going on. So something like where there's a performance issue and we call it a reorganisation, and it isn't really a redundancy situation. That could be a breach of the implied term of trust and confidence. Not having reasonable cause to suspend somebody could be a breach of the implied term. Singling somebody out for differential treatment could be a breach of the implied term. So something like giving everybody a pay rise or an increase to their pension or bonus or something like that, but not this one person. There's a dovetail with other things like disability discrimination, so failure to make reasonable adjustments could equally be a breach of the implied term of trust and confidence. It will also extend to things like giving people an excessive workload, that overlap that I mentioned before with bullying and harassment, and things like a tolerable working environment. In any situation, the employee's still got to identify what it is that the employer has done wrong in that sense. There will be a concept I'm sure you'll be aware of, a cumulative effect of a series of events on the part of the employer. So the employee is entitled to say that was the last straw in a series of events. So even though the last straw in itself might not be a fundamental breach of contract, the employee argues that the cumulative effect, the build-up of a series of events, tips them over into that situation where they can say it's so serious they have to bring the contract to an end. The challenge, of course, for the employee in those situations is to show that it is sufficiently serious. The next video that I do will talk about some of the other ingredients that are necessary to claim constructive dismissal. If anyone has got any questions, my email is adenton@refreshinglawltd.co.uk. Thank you very much.